Election Commissioner is now in session, and this meeting is open to the public. In accordance with holding a meeting open to the public, if any members of the public in attendance today would like to provide a public comment before we begin the official business at hand, you may do so now. Otherwise, we will move on to begin today's hearings. The County of Peoria Board of Election Commissioners is the properly constituted electoral board pursuant to 10 ILCS 5/10-9. The parties wishing to be heard should have signed an appearance form at the sign-in table. I think you guys have been provided those. If you have not done so, please do so now. The electoral board will conduct hearings for the purpose of receiving evidence and hearing argument relevant to the issues presented by the objections raised in the objectors' petitions. With regard to the substance of the objections, the objector must bear the burden of proving by operation of law and by a preponderance of the relevant and admissible evidence the burden of proof that the objections are true. The board will first adopt rules of procedure for the Board of Election Commissioners of the County of Peoria as the duly constituted electoral board for hearing and passing upon objections to nomination papers. I will entertain a motion to adopt the rules of order. Got a motion by Dr. Pino. Second by Mark. Any questions or comments on the motion? Hearing none, all in favor say aye. Aye. Any opposed? Motion carries. The public hearings will proceed in an orderly fashion, and I would like to ask your cooperation in the following procedures. Oh, sure. Before we move ahead, I want to get signatures for the rules.
I can do that.
Thank you. Public hearings will proceed in an orderly fashion. I would like to ask your cooperation in the following procedures. All comments should be made from your seat in individual microphones, and any individual making comments shall first give his name his or her name and address. Please speak into the microphone slowly and clearly. This is required because an official recorded transcript of the hearing is being made. If there's an appeal, the court must make its decision on the basis of what was said here today. If anyone requires special accommodations in order to speak, please let me know and we will make those arrangements. This is the time for presentation of testimony. No debate is allowed. These rules are intended to promote an orderly system of holding a public hearing to give every person an opportunity to be heard. Each party may make a brief opening statement. It should be limited to what the party intends to prove and should not be a presentation of evidence or the merits of the case. The objector will present his evidence and or argument case in chief first. The respondent, the candidate, shall be given the opportunity to cross-examine the objector's witnesses and present his or her own witnesses or present evidence. After a respondent has completed his defense, the objector shall be given the opportunity to present testimony and or evidence limited to the rebutting of the testimony and or evidence presented during the respondent's defense or the rebuttal. Each party may make a closing argument. The parties are directed to limit their closing argument to a summation of what he believes has been proven. The board will utilize its rules of procedure to conduct and preside over all hearings. At this time, I would call case number 20-04, a hearing on the petition of Anthony Walraven objecting to the nominating papers of Corey Thomas. The board will now, before we move on to that, are there any preliminary matters before we move to opening statements? Could use your microphone, Doctor.
My name is Arun Pinto. I just wanted to make everybody aware, in case there are objections, that I know Mr. Walraven personally and professionally, and so if there's any considered conflict of interest to me participating in voting, I'd like that to be known up front.
Thank you, Dr. Pinto. Are there any objections or dispute Dr. Pinto's participation in today's hearings?
I have no objection.
Mr. Thomas? Okay. The board will now take judicial notice of the following documents: nomination papers, objection petition, voter registration records kept by the Peoria County Election Office, record examination conducted by the Peoria County Election Office, number of registered voters in the general election in 2018.
It's the number of voters in the general election in 2017, not 18.
Excuse me, correction, it was the number of registered voters in the general election in 2017. Are there any other documents that either party would like the board to take for judicial notice?
It may have been on my part.
I think you turned the microphone off when you...
Oh, I'm sorry. Yeah, this is my first time being challenged in this, obviously. I didn't know what to expect or anything preparation. I was given only a few days to get prepared and to address this court or this hearing.
This is all information and documents that are public records that everyone has access to. So we just want to make sure if you guys had additional documentation to present to the board, we would accept it at this point.
Well, that's what I'm saying. I wouldn't have any extra documentation not knowing what.
Understood.
None for the objector either.
We'll start off by opening statements. The parties will now proceed with their opening statements, beginning with the objector, then the respondent. Mr. Hanauer.
I'll be brief. Rob Hanauer on behalf of Anthony Walraven, the objector. He resides at 1927 West Hudson Street, Peoria, Illinois 61604. I don't really, there's not going to be any evidence by the objector. It's going to be technical arguments that many of you have heard me make before. So I will waive any further statement. Thank you.
Mr. Thomas.
Again, I don't really understand these proceedings as well as the objector and his representation, but I'm here to represent that during this pandemic, it's been very hard for everybody, and it's an even playing field, I understand, but you know, some of the regular rules of getting petitions signed, it was just kind of hard. And in my defense, also, my job is a very high demanding job where it makes it very hard to come up with a lot of stuff. So of what's required.
Thank you. We'll move on to the presentation of evidence, beginning with the objector.
No evidence, just argument. Thank you.
Mr. Thomas, do you have any evidence to present?
I have a text message. Like I said, I wasn't prepared for this, but I do have a text message of one of the volunteers that got a lot of our signatures. She can arrive. She can be here if I call her. But I just have a simple text message of giving her post-dated an address of the notifier. So
I would object. A text message would be hearsay and inadmissible.
there's no dialogue.
If you could just clarify what evidence that could potentially be through text.
If they're questioning by argument that I was not the only circulator, I have other circulators with the text messages that will prove that we have other circulators and where she got most of her signatures from, if that's relevant.
I mean,
Again,
I think it's relevant if the witness was here for us to swear in. I would agree with, although I know you don't have legal representation, I would agree with Mr. Hanauer that text message may not be the most appropriate information at this juncture. A witness being sworn in, I think, would be more prudent and appropriate.
and again, it was very short time. I was notified just Saturday, and papers was brought to my house. So I was totally oblivious to this hearing.
I think at this time, from the board's perspective, the commission's perspective, I'd like to call Tom, our executive director of the election commission, as a witness to present the findings from the commission that were taken through judicial notice. Tom, if you could stand and raise your right hand, please. Sure. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do. So the Election Commission staff did an analysis based on the petition that was filed to, the objection petition that was filed to Mr. Thomas's petitions. The analysis showed that there were, based on the number of votes cast in the mayoral election in 2017, there was 134 signatures required. Mr. Thomas's petitions contained 199 signatures on 24 pages. Mr. Walraven challenged 78 of the 199 signatures as unqualified voters. Walraven challenged the addresses of 18 of the petition sheets as different from the statement of candidacy. Our analysis is that 68 of the challenged were not registered at the listed address, or not registered within the city of Peoria. 68 of those 78 were found unqualified. The conclusion was 199 signatures submitted, 68 were found invalid, leaving 131 valid signatures after the challenge. The question of the address, there is no 2316 North Avenue in Peoria County. There's actually no North Avenue in Peoria County, but the 2316 North Street is a valid address. And I've got also a notice is the actual spreadsheet breakdown that we used to come up with our conclusions.
Mr. Hanauer, do you have any questions for Tom?
Yes. In the objector's petition, or the objector's challenge, he indicated that there is a sheet that contains the name of the candidate as, quote, Peoria. Did you count the signatures on that sheet?
We counted every signature. The only the analysis we did was whether or not the signature that was objected to was a valid registered voter or not. We did not look into whether or not the whole sheet should be declared invalid based on other information on the sheet. We simply looked at, is this person registered to vote? If they're registered to vote, are they registered to vote at that address? Or are they in the district, the city of Peoria? We didn't get into, we read that as a legal distinction, so we looked at specifically whether that signature was a valid registered voter in the city of Peoria.
Understood. Thank you.
Mr. Thomas, do you have any questions for Tom?
So you already concluded that because my address is an avenue on a few petitions instead of North Street, which is my personal residence, may have been confused with someone else, that is canceling out signatures.
No, the only reason I brought up the address is because it's listed a couple different ways. My point was that there's a North Street, but there isn't a North Avenue. So the point was, we didn't think you could confuse North Street with North Avenue because there isn't a North Avenue in Peoria County. There's a North Street. There isn't even a North, like, there's a couple other streets that have North in them, but none of them are North and South, and they wouldn't be easily confused. So that's why I brought up the North Street, is that there isn't a 2316 North Avenue. There's only a 26 Street. There isn't even a North Avenue in Peoria County.
Okay, and it gets confusing also when you say north.
Yes.
You know what I mean? So, what is the validity of the avenue? What does that?
There was a couple of the petitions that the objections were that it was listed as Avenue on a couple of petitions. So we just wanted to address that there isn't an actual North Avenue in Peoria County.
I got you. Have you concluded that 68 signatures are not valid?
Yes, 68, we looked at the ones that were challenged, and out of the 78, we concluded that 68 of those people they're either not registered at address, or they're not registered in the city of Peoria. So that wouldn't be a valid signature on the petitions.
And that's the final conclusion, meaning up until early voting, mail-in voting, and even election day, you can register up to become a registered voter. And I know this is 2017, so excuse my dialect or my definition, because
Doing fine.
I'm not in this arena every day. So
You're doing fine. The
please.
question was, Tom, are they most up to date
Yeah,
information based on the last election? Or are you going back to 2017?
no, the evaluation was done last Friday morning based on the most current voter registration information in Peoria County.
So the potential voters here in Peoria that sign my petition as supporters, they're just going to be excluded from being a participant in this election.
No,
I'm just going to objection. It's to relevance and to the extent that it calls for a legal conclusion.
For the sake of this process, I want to at least allow Mr. Thomas to explain or better describe his question to Tom, if you would, please.
So I'm not really familiar with it, but I think everyone that doesn't feel that their voices are heard, that I normally represent on a day-to-day basis as an essential worker with a food bank at that. I don't just represent this city, I represent counties, and I represent both parties. It's really nonpartisan on my end. But there are a lot of people, as proven in 2017, that my candidacy has what was brought to me as encouragement, paved, broke the ice road for more candidacy, more participation, and I'm definitely a grassroots candidate, so I want to represent those that's not being heard, and this proceeding is possibly going to allow voters and citizens of this city, both productive and unproductive in the city, and that's what I base my whole candidacy around. And if those signatures are not represented, then we're a part of a party, we're a part of a group that is the norm when it comes to being a registered voter, so to speak. And those who may be unregistered in 2017 to this current day are those that are interested in this election as well. I stood just about
I would
on my
object
own.
to the extent that we're really in argument now.
Yeah, I mean,
not
at
questioning.
this
I'm
point, we're
talking
still presenting questions to the witness, and Tom being the witness, you are going to have a closing argument after the objector, if you want to make those type of statements. But at this point, we'll leave it to questions for the witness.
So the board is content with not allowing citizens of this community that may have not been interested in voting up until the last 2017 until now, not knowing the processes and what's required. I can't say I'm always there to explain these things, so they would not be allowed on this board's contemplation to be considered as a voter.
Objection, that calls for speculation. He is not the board, nor is he a member of the board. And it presupposes the end.
Glad you know that,
result of these
Rob.
proceedings.
I'm glad you know that.
If you could present your question to the witness as opposed to the board of commissioners.
So will you, as a witness, be conscious and convicted enough to say that these registered names will not be admitted, even though they're potential voters,
Our,
citizens?
our job was to analyze the petitions based on the challenge. And what we did is we looked at the challenges and verified whether they were or were not a registered voter in Peoria County. And if they were a registered voter, if they were registered at the address they wrote on, that was the only analysis we did. They either were a registered voter at that address or they weren't a registered voter at that address.
That's with no age limit. Some of these voters may have just turned 18.
If they were registered to vote when we did the analysis, then the signature was, we considered it, they were registered to vote.
At this point, I have no questions that it may be relevant at this point.
No more questions. We'll move on to the objector's closing argument. Excuse me. Yeah, while we still have the witness on the stand, do you guys have any, does the board have any questions for Tom? Okay, hearing none, we'll move on to the objector's closing argument.
Thank you. Generally speaking, there are two types of requirements under the Illinois Election Code. There are directory requirements that substantial compliance is sufficient, and there are mandatory requirements where strict compliance is required. The signature requirement is a strict compliance requirement in the election code. It's calculated, and the board took judicial notice of the signatures or the votes that were cast in the 2017 election. It is based upon that. And that calculation is 134 signatures, which is what Mr. Bride testified to. And I've been here before arguing and explaining that you have to be a qualified elector / registered voter as it's defined in the code. There's a case, Stout v. Black, that says when the various provisions of the election code are read in para materia, meaning together, and within the purview of the purposes of the code, the legislature intended that the signers of nominating petitions for an office to be voted upon in an election in which registration is a prerequisite to voting must be registered. That's Stout v. Black 8, ILAP 3rd 167 at 169 to 170. There's one other case, Green v. Board of Election Commissioners of the City of Chicago. A person who signs a nominating petition, and the emphasis closes this quote out, and it was included in the case, must be registered to vote at the residence address set forth on the nominating petition. So if you strike if you strike the, and I did the same calculation as Mr. Bride, if you strike those that were not registered in Peoria, that brings the count to 160 from 199, which was where Mr. Thomas started. If you strike the ones that were not registered at the address shown on the signature sheet, that brings him down to 131. There were actually two duplicates. Now, I don't know if that brings him down to 129 or 131. I don't believe the duplicates were counted in the commission's analysis. But I will say, in addition to that, to the extent that there was a sheet that identified the candidate as Peoria, every signature on that sheet, not all of them, but every signature on that sheet should be stricken. And the reason is because at the top of every signature sheet, there's going to be fill-in-the-blank spots for the candidate's name, the office that's sought, to the extent that it's going to be a full term or an unexpired term, you're supposed to check the box indicating that. This is a form that is created by the State Board of Elections. The reason for the top portion of that is to make sure that whoever signs that sheet, the 10 or 15 signatures below, depending on which sheet you're using, which form you're using, they know who is running, what office they're running for, and if it's a full or unexpired term. And it's really only relevant when there's some full and some partial terms. It happened in 2017 in the at-large race, as you guys recall, where Sid Ruckriegel and Zach Euler won the partial unexpired terms for 2 years. Now, there are you don't find this scenario where the candidate misstated or the circulator misstated the candidate's name where the candidate's name should go. I didn't find any cases in my research, but what I have found is where the office sought was improperly placed in there or not placed in there. That was enough to create confusion around the office sought, and that confusion, anywhere that there's where confusion can happen in a nominating sheet, it should be stricken. There's a case that says, and it's Salgado v. Marquez, 356 Illap 3rd, 1072. It says, in determining whether a candidate has complied with Section 710, which is the requirements of the election code at the top of those sheets, Lewis, which is another case, sets forth two requirements. First, and the only one relevant here, the nominating papers as a whole must not create a basis for confusion as to the office sought. Now, that talks about the office, but the same would apply where there could be confusion as to who is running for the office. If you've got a sheet that doesn't have the candidate's name on the name of the candidate line, there's confusion, clearly, or at least the possibility of confusion. And there are cases where candidates have created a nickname. One such case, Rita v. Maiden, 364 Illap 3rd, 913. The candidate in that case listed themselves as the coach. And the coach violated the election code with respect to giving a nickname that tries to impart something, tell something about the candidate. You can basically have Mr. or Mrs. or a name that you're commonly known as. But to the extent that Peoria was the name identified on one sheet, that would invalidate only that sheet, in addition to all of the signatures where they were not registered to vote in Peoria, or had some other deficiency that Mr. Bride's testimony has already indicated existed. For that reason, there's at least a shortage of 3 signatures. The reality is the shortage could be far more, because that sheet it would be appropriate to strike that sheet in addition to all the other signatures. And for that reason, I recognize the argument that was made in the questions. I know Mr. Thomas, he's a nice person, but the rules were set up a certain way. Everybody has to comply with them. this board has stricken candidates from ballots for this very argument. And it would be, honestly, it would be improper and unjust to not strike Mr. Thomas when other people have been stricken for the exact same reason that's being argued here. And for that reason, I would ask that the objection of Anthony Walraven be sustained. Thank you.
I appreciate you saying I'm a nice guy. I try and intend on that on a daily basis, working at a food bank, and as essential as I've been over these years, over a course of 10 years. I do appreciate that you don't have the same characteristic that you just gave to me. You know, you're like Anthony, you know, you like to agitate a lot of things, and there's a lot of possibilities of names being stricken, of however confused you may feel about these signatures and petitions. But what is not confused is my second candidacy. And when these people signed this petition, they weren't confused whether it was Peoria, Corey for Peoria, or Corey Thomas's candidate. That was always being a open line to any person that signs these sheets. I have no doubt you may find some, as your diligence has served some names, but in the end of the game, end of the day, with this pandemic, the workload I work every day. The workload that causes, and this pandemic, some confusion in how we are to get signatures from individuals, not being able to really be approached, to be able to approach citizens and residents to get signed signatures. It may have been a little confusion with the new volunteers that help get these signatures. I don't think by any means we should go off of probability or an argument of, I'm sure, like you said, you've been here before, that you're used to striking names and trying to get voices from names off of a petition or a ballot to exclude voices in this community. So as I said in that questioning period, that these are new voters. There are people that has been inspired since 2017 without knowing the legal recommendations for signing signatures to get your name on petitions. It's more of excitement. It's more of oh yeah, I remember you. And it's not any confusion of those people. And like I said, whether it's going to take more education, and it's going to take more education to our community from our leaders, our board, even if he stepped up to be a leader instead of representing someone that has been a known agitator here in Peoria and the group. I am very surprised to see Rob representing Anthony, and Anthony not being here himself, because he called me away from my job. So that's why I'm dressed the way I am. I'm still not warm. And this is something it's something I deal with all year round. To deal with this is just an added stress. My car was stolen Sunday. I retrieved it late Sunday night. Found all of my, this is not relevant to the case, but found all of my belongings at Peoria High School just today. And it gave me more motivation to represent this community even greater. So having cut out and carved out the snow of the election process in 2017 as a willing and ignorant candidate at that time, to not see how these proceedings should go, I also saw teammates and candidacies on this ballot that suggested the same things in 2017. It does not surprise me that Anthony raised these challenges. I obviously in this hustle and bustle time, and it's segregated time from each other, it's very hard to be able to get individuals to have all this knowledge packed in a short amount of time of being able to get a petition and actually submitting the petitions, it's been very challenging. So I don't want to elaborate too much on the issue. I don't want to be canceled out. I don't want to go the rest, until April or February, not knowing if I should have done it, or you're going to make the conscious, no convicted statements and non-convictions of allowing a candidate that had no issues. And I don't know how many signatures I had last time, maybe 400 or 500. Obviously, that's been hit this year. So I'll just leave my statement as that and rest your ruling on this board.
Mr. Hanauer, your rebuttal.
I would argue that even if we want to rule in favor of Mr. Thomas, nullification of the laws of the state of Illinois is inappropriate here, and the laws of the state of Illinois are clear. This is required. There's a required number of signatures, 134. He came up shy, and many of the people aren't registered voters at all. So it's not like you're disenfranchising voters. They're not voters. Thank you.
Thanks to both the parties for your presentation today. At this time, I'd ask the electoral board to make a motion to conclude the hearing for the purpose of presentation of evidence and to proceed with deliberations.
So moved.
Second.
Got a motion and a second. Any questions or comments on the motion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion carries. So we're to the point of deliberations. If anybody's got any comments, the floor is open. Yeah, Sandy. If you could, Sandy, use your microphone, please.
Mr. Thomas had indicated that he had just gotten the information that this hearing was going to take place this past Saturday. Is that true? So my concern is that he really hasn't had an opportunity to review the objection or prepare any kind of statement or even to question any of the signatures himself. I would think that he should have been allowed to have gotten more notice that this was going to take place, so that he would have time to come to this hearing prepared.
Yeah, 1 second, Sandy.
That's when the notice was made, right?
Yeah, I think, my opinion on that matter is the notice was made on Friday. Mr. Thomas has had several conversations with State's Attorney's Office, and in the past, if we have always granted extensions to candidates and or objectors based on circumstances, especially as it relates to timing. That was never brought up in conversations to the State's Attorney's Office. And furthermore, today wasn't even asked for a continuance. We all have been working with the same information and the same notices, and I think this body has always been cooperative and flexible in allowing both candidates and objectors the time to prepare, both from a legal standpoint and just from a timeline and a matter of gathering information. That's my perspective.
Am I allowed to make a statement on that?
We're closed now. It may be appropriate, just based on what's been presented today, that we kind of go through the following findings to help walk through the next steps or decision making. I will say our first finding is we know that the Peoria County Board of Election Commissioners is the properly constituted electoral board and has jurisdiction of the subject matter in each parties to this case, to this cause. Proper notice regarding the hearing on the objection was provided. We know that on November 23rd, 2020, candidate Thomas filed nomination papers for the office of mayor of the city of Peoria. We also know that on December 2nd, 2020, the objector filed an objection to the candidate's nomination papers. We know that the candidate submitted 24 pages of signature sheets. We know that the candidate petition required 134 signatures of addresses of qualified voters for candidates to be placed on the ballot. Based on the analysis that Tom and his staff provided to us, we know that the petitions contained 199 signatures. And based on that analysis, 68 of the challenged were not registered at a listed address, or not registered within the city of Peoria. Therefore, the 68 deducted from the 199 would leave candidate Thomas 131 valid signatures. Are there any other findings pertinent to the decision making that you know of? Anything else from the board?
I'm still a little confused about this one page, 131 and 134. If he had the time to review the individuals that were supposedly not registered or didn't live at the addresses and so forth. I mean, we're only talking a couple of people to qualify. I don't quite fully understand this issue about the address at the top of the page that would invalidate the whole page. Which would make it a few more
Yeah, I don't think
wider for the
I don't even think
134
that's
he needed.
really come into question, at least from an argument standpoint. We talked about the 68 just being registered or not registered voters.
Right.
That would bring it to the 131. We haven't even really taken into consideration or put much thought or discussion surrounding the address of the first. It would be considered page 1. Or excuse me.
So,
I don't believe that Tom
Yeah, hang on,
numbers.
Jim, hang on one second. I want to make sure I'm answering Sandy's question. Which page was it that didn't say mayor on it? Sandy, I want to make sure I'm understanding your question correctly. Are you talking about the North Street versus Avenue, or are you talking about the entire page being removed?
that was my understanding, that there was a possibility that a whole page of names would be disqualified because of some discrepancies in the address.
Oh, okay.
Okay,
So
so
page
if that
1
wasn't taken into consideration, we're only talking the difference between 134 and 131.
No, 134 is required, but removing the 68 unregistered voters would bring them to the 131.
Would bring them to the 131.
Correct.
It's right that you didn't disqualify those signatures on the page where the heading was wrong.
I'm not sure that it's necessary to even go into that conversation.
Well, right,
But I want to
so-
make sure that I'm answering Sandy's
But the-
question. On
right.
page 1, it would be page 1 of the petition sheets. where it is the name of the candidate, it reads Peoria and not Corey Thomas or Cornelius Thomas. No, no.
Oh,
And
I
just so we're clear, those have not, those names, those 10 names on page 1 have not been subtracted.
Okay, all right. So my point is that there's only a difference of about 3 signatures that he needed to qualify.
Registered voters,
Yeah.
there is a
or
difference of
registered
3.
voters.
That's correct.
And considering the fact that he didn't have the time to adequately address even the objection. As he said when he came in and he wasn't even aware that what this was all about. I would think it would be fair to at least give him an extension to review some of the names and to go back. I mean, considering the fact also that some of these people may be registered to vote recently with the election. Is that possible?
No.
I was just gonna, so procedurally in the hearing, Mr. Thomas didn't ask for an extension of time or a continuance. So procedurally, we just don't, the commission does not have that before them as a option to vote on, to extend time. So that's one thing procedurally. And then, the analysis done by the election office is based on who was registered on Friday when they did the analysis, like 3 days ago. So every signature that was analyzed as whether or not they were registered, that is as of Friday. 2017 is only how we came to the number of 134 signatures needed. So if the commissioners want to open back up to ask Tom additional questions, I think you could make that motion. But I just wanted to clarify that that's the information that we're operating under.
Well, I'm going to bring it up. I would like to open up the questioning to Tom, just so I'm clear.
Can make that motion.
To move to open it to
Got it.
question.
We've got a motion to open up questioning to our witness. Is there a second? Is there a second?
I'll second that, so she has an opportunity to ask Tom a question.
Okay, there's a motion and a second. All in favor, say aye.
Aye.
Any opposed? Okay, motion carried. Go ahead, Sandy.
All right, so my question to Tom, the 134 was based on the 2017 elections, right? What other options?
Correct. That's the number of the total votes cast for mayor in the last election that the mayor was on, which was the 2017. So that was 1% of the total votes cast for the mayor in 2017. That's where the 134 calculation came from.
What other options exist for determining the number of signatures that are needed on the petition? Is that the only way we determine?
Yeah, the statute is clear that it's
134.
1% of the total votes cast for the last election
Last
that office was, yes.
Sandy, can you speak into the microphone, please?
Oh, I'm sorry.
Thank you.
Forget that it's here. All right, so the 134 is pretty clear based on the statutes that the number of necessary signatures is 134.
Correct. And we, that number was included in information that we put on our website and that we gave to candidates who requested information from us.
Okay, all right. Has there been any instances where a candidate has questioned or asked that the count of registered voters be re-examined, and that's been considered.
Anytime that any electoral board I've been a part of, the examination from the staff was accepted.
That concludes my questioning to Tom.
Any other questions for Tom? We'll require a motion to close as well and go back to deliberations. I've got a motion by Dr. Peno. Second by Mark. Any questions or comments on the motion? All in favor, say aye.
Aye.
Any opposed? That carries. We're back in deliberations. Mark. Are there any other comments?
I have a question, Matt. So we're basing this judgment just on one of the objections. We could go back, if we had to, we could go back and dig deeper. I believe you presented other objections also, correct? Like the Peoria, where it should have the candidate's name. So we're just going as far as we need to determine a finding.
Yeah, I mean, once the 134 is not satisfied, there's, in my opinion, there's no reason to find more voters to take, or more registered voters to remove. So yeah, to answer your question, yes, the 68, the reduction of 68 is just solely based on whether they are registered voters or not. And page number 1 with the name Peoria in the line of where the candidate's name should go has no bearing on the 68.
Okay, thank you.
Well, I mean, it's up to the entire board, but yeah, I mean, it would definitely be open for discussion and interpretation on whether this board would consider that page removed as well. If there's no other comments, do I need to make a motion on the fine? Is there a motion to accept the proposed findings?
So moved.
Got a motion? Seconded by Dr. Peno. Any questions or comments on the motion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Having made those findings, is there a motion with respect to Mr. Walraven's objection? Remember, the motion could be made in the form of sustaining his objection, which would remove Mr. Thomas from the ballot, or rejecting, which he would remain on the ballot. I've got a motion to sustain the objection by Dr. Peno.
Second.
Got a second by Mark. Any questions, comments on the motion? All in favor, say aye.
Aye.
Any opposed? That passes unanimously. Section 10-10 of the Election Code requires the Electoral Board must put its findings in writing and indicate which objections, if any, It is sustained. That written decision then has to be served upon the parties in open proceedings before the electoral board. Since we need time to draft a written decision, I suggest that we briefly continue the hearing on this matter and we need to come up with a date, and I think it's appropriate to set the date now. How does Monday look for you guys? Yeah, it would be Monday the 14th, sometime potentially early afternoon or a similar time.
I'm good.
Early afternoon works.
Say 2 o'clock.
Mr. Chairman, are we going to be reconvening even the parties here, or just the board?
The board, but it will be an open meeting.
Okay, thank you.
Did we decide where? Is it here? or-
So it will be at the Election Commission.
Okay.
Monday the 14th at 2 for the purpose of service of the written decision. I'd like to clarify that the presentation of evidence has already been closed and the decision on the objection has been rendered. So the only purpose for continuing this matter is to allow the electoral board to put the findings that we made today into writing and to distribute them to the parties. I'd also note that although the statute requires us to provide the written decision in an open meeting, the parties may, but are not required to appear. And if they choose not to, the statute also allows for service of the written decision by mail. The parties can also agree to be served with the written decision by fax or email. Okay. So then I would suggest reconvene on case number 20-04 on December 14th at 2 p.m. at the Peoria County Election Commission, which is located at 4422 Brandywine Drive, Suite 1, Peoria, Illinois, solely for the purpose of distributing the written decision to the candidates. Would anyone care to make a motion to that effect?
So moved.
Second.
Motion and a second. Any questions on the motion? All in favor, say aye.
Aye.
Any opposed? Motion carries. That concludes our hearing for case number 20-04. And I would suggest that we take a 10-minute recess. You guys okay with that? Just what? Yeah. And we'll reconvene at 4:25.